Good evening, this is BrassTacks. I'm Zaka Jacob. The Supreme Court today granted interim bail to Alt News co-founder Mohammed Zubair in all the cases filed against him by the UP police. The court also ruled that all the cases with concurring charges be clubbed together and be investigated by one agency, in this case, the Delhi police. Now, in doing so, the court has upheld a long-standing judicial principle that for the same offence arising out of the same cause of action, there can only be one investigation, one FIR, and one agency. Should the court extend the same judicial principle, which it has upheld in numerous judgments, to Nupur Sharma as well? After all, she knocked on the doors of the Supreme Court for the very same rationale, that there are multiple FIRs in multiple states against her for the same offence and the same cause of action. What applies to Zubair should apply to Nupur as well.
The Supreme Court put an end to what it called a vicious circle involving Alt News co-founder Mohammed Zubair, granting interim bail in all 6 cases against him and ordering his release. The Supreme Court said that the bar of arrest must be pursued sparingly. The top court disbanded a special investigation team probe in Uttar Pradesh against Mohammed Zubair and transferred all UP cases against him to Delhi. While the Supreme Court did not cancel the FIRs, it said he was free to approach the Delhi High Court against all the cases, which can be combined into one. The order on transfer of FIRs to Delhi will be applicable to cases in other states and to any future complaints lodged against him. The judges also rejected the Uttar Pradesh government's request that Mohammed Zubair be stopped from putting out tweets. Justice D.Y. Chandrachud said, and I quote, "How can you tell a journalist he cannot write? If he does something that violates the law, then he is answerable to the law. But how can we take anticipatory action against a citizen when he's raising his voice?" Unquote. So will Zubair's release set a precedent? Should the principle of clubbing FIRs and using the power of arrest sparingly apply to all?
All right, on the debate tonight, I'm joined by Smita Prakash, editor ANI, Ratan Sharda, RSS researcher and author joining us, Swapnil Kothari, lawyer, Adil Singh Bopra of the Congress will be joining us as well, and Yashwardhan Azad, former IPS officer. Smita, let me start with you first. Yes, what the court has done today is to uphold a long-standing judicial principle that for the same offence with the same cause of action, there can only be one FIR, one investigating agency. Therefore, it's clubbed all the UP FIRs and given it to the Delhi Police Special Cell to investigate. Should that same principle apply to whether it is a Nupur or a Rahul or a Rohit or whoever it is? We've seen numerous instances, even in the recent past, for the same offence, multiple FIRs being lodged in multiple states.
Well, Zubair got bail, Nupur won't be arrested. That's what we've learned today. And may I dare to say that one can see a kind of a glasnost in the judiciary. I mean, it's wonderful, of course, that the Honorable Apex Court seems very, very gentle and kind today, sensitive to the rights of civil society. And I'm not being sarcastic, I'm genuinely saying it. There were no caustic comments on Zubair. That was to be expected. But the honorable judges had no caustic comments to make on Nupur either. The FIRs are not quashed on Zubair and not quashed on Nupur's case either. I mean, the investigations will continue in both the cases. And but you know, if the Apex Court has woken up today and wants to do what it is mandated to do, which is that innocents are not harassed, then maybe the lower courts, the judges in the lower courts will also wake up to that and will ensure that citizens are not thrown into jails and not rotting in jails as under trials for years on end. Zaka, what we have here today, or not today, what we are seeing in the past couple of years is that, you know, this perennial problem of constitutional law in conflict with criminal law. Constitutional law focuses on protection of citizens' liberty from state coercion or from coercion by a political party, by the bureaucracy or by anybody. Whereas criminal law gives muscle to the state for coercive action, and even when there is a hint of crime that is taking place. And it's clear evidence today that, you know, the courts are now waking up to the fact that It can work both ways. And so while Nupur is facing threat to life, not just from loonies in India and from abroad also, Zubair's lawyer said today that he too is facing threat of violence.
Yeah.
So if it is clubbing of FIRs and if it is investigation, it should happen technically in both cases.
I want to ask Ratan Sharda this as well. In Zubair's case, he was asked to come to Delhi for a particular case. He was arrested in Delhi first for a case involving a tweet that he put out in 2018 purportedly. And then subsequently, the UP police filed as many as 6 FIRs against him in Lakhimpur, in Sitapur, in Hathras, etc. All of which today the Supreme Court has said at least the UP cases will be clubbed into one and will be investigated by the Delhi police. In Nupur Sharma's case as well, I want to ask Ratan Sharda, she made one offensive statement in one TV debate at one place, but there are offences that have been registered against her from Rajasthan to West Bengal to even in the south. So shouldn't the same principle apply to Nupur Sharma as well?
Zaka, thanks for raising this particular point, because this point was raised earlier also, but nobody took it seriously or people wanted to avoid the question. First of all, I must thank the courts that they have realized that people are being harassed, whether from one side or the other, they are being harassed. And when they were looking at Nupur Sharma case and Zubair case, there is a marked difference. Though the justice at the end of the day was much better than that was meted out to Nupur Sharma in the first hearing. See, justice should be seen, not just being done, it should be seen to be done.
Yeah.
Law should be seen equal to all, and not just seen, but also we take the taste of that particular equality before law, which was not so. For example, in case of Nupur Sharma, judges said, what is her business to make those remarks? For Zubair, they said, how can I stop him from tweeting? He's not a journalist himself, but the judges claimed he's a journalist. So journalists can make offensive statements perhaps, but others cannot. Politicians cannot. People like me and you cannot. He says her petition smacks of arrogance, while in case of this fellow Zubair, it says subject of fairly sustained probe by police. There are a lot more examples. Single-handedly responsible for what happened in the country, and for Zubair, he says continued detention not justified. So all these things show me that though judges have tried to be equal-handed now, but actually they were not. For example, there is a case, very celebrated case of High Court, T.T. Anthony case, which says that only one FIR can be filed for a particular offense. In case of both, multiple FIRs were fired, but when the clubbing of the cases came, Nupur was handled very, very roughly in a very, very insulting manner, but this person gets the same benefit, which was due to both of them.
Okay.
So I would say that yes, I do not believe in harassing people of whichever side with multiple FIRs, but there are clear-cut judgments. Then why did Supreme Court make her go to courts which are not even justified? They didn't have a scope.
So I want to quote from that T.T. Anthony versus State of Kerala verdict. It was in 2001. The Supreme Court basically said that there cannot be a second FIR on the same issue. This is what the court said in that judgment, and I want to ask Adil Boparai to weigh in on this, because this should apply even-handedly to all cases, whether your name is Nupur or your name is Zubair or your name is Arnab or your name is Rohit or Rahul. There can be no second FIR, and consequently there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offence or the same occurrence or incident giving rise to one or more cognizable offences. Again, I keep going back to the same thing. If Zubair had put out one tweet and there are multiple cases arising out of that one tweet, the same principle should extend to Nupur as well. It was one comment made in one TV show at one place. There cannot be 9 different FIRs in 9 different places.
Zaka, in lighter vein, you would have made a good lawyer. But having said this, I'll request for 120 seconds of uninterrupted time. We welcome the order of the Honorable Supreme Court. The Supreme Court has reaffirmed the principle that there cannot be multiple FIRs arising out of the same cause of action. That's the settled law, not just in T.T. Anthony, but even consequently, it's been followed by the Supreme Court in a host of cases. But having said this, I want to highlight a critical issue which has not been raised by the previous panelists so far, which is that there has been differential, and I underline, there has been differential police action. And I will give you an illustration. You've had instances like Munawar Faruqi. You've had instances like Zubair. You've had instances like Professor Ratan Lal of the Delhi University, where the police zealously, promptly, and swiftly made arrests. And on the other hand, you've had instances like the BJP spokespersons, where there has been no arrest. So doesn't this smack of double standards? Doesn't this smack of differential treatment by the executive and the police? This is point number 2. Point number 3, I completely concur with the underlying principle which was raised by the previous 2 speakers, that the process is becoming a punishment.
Yeah.
And I'm glad that the Supreme Court has intervened that yes, there should not be multiple FIRs, but at the same time, comparing Nupur Sharma and Zubair is like comparing apples with oranges. Because on one hand, you have rabble-rousers who've indulged in hate speech, who according to the government of India is the fringe element. Forget what the Congress party say. The government of India says that it is fringe element. And on the other hand, you have a fact checker who's reported hate. So therefore, you can't draw comparisons between the two. Having said
No,
this,
I'm not going into I'm not
under-
going into the merits. No, one second, Adil. One clarification. I'm not going into the merits of either cases, either of Nupur or that of Zubair. That's for the courts to decide. But if you consider what Nupur said is hate speech, then there are umpteen tweets that Zubair has also put out which can be construed as hate speech. Ultimately, it has to be proven in a court of law. But I take your point. I take your point on the principle of arrest.
30 seconds. Follow
Okay,
up.
30 seconds more. Okay, 30
30
seconds, yeah.
Zaka, the elephant in the room, and I hope you put this question to the previous 2 speakers. Zubair was arrested for an offence which carries a sentence under 7 years. Munawar Farooqi was arrested. Similar offences. Professor Ratan Lal was arrested. Similar offences. Why the red carpet for the BJP spokespersons? Why no arrest? The protection came yesterday or day before yesterday. There was no protection for a good 1 month. Why did the police not make an arrest there and swiftly made an arrest here?
Okay.
So what's the message?
On the differential use of the threat of arrest. Okay, let me ask that. Let me ask that to a former cop. Yashwardhan Azad is on the debate tonight. The court also said today, and I want you to weigh in on this as well as what Adil said, that the power or the threat of arrest is being used differently for different accused persons. The court upheld that the fear of arrest cannot be used as a weapon by the state, that the existence of the power of arrest must be pursued sparingly. That's what the court said today in the Zubair case. But also answer Adil's point that in Nupur's case, she was not arrested. Although the charges against her were pending for a month and a half, she got relief yesterday from the Supreme Court, but the Delhi police took no cogent action to take her into custody, whereas in the case of Zubair, they brought him to Delhi on the pretext of one case and then arrested him for other cases. Please explain.
I totally appreciate Mr. Boparai's point that the Delhi police, though despite giving a great explanation that she was called under 41A and she cooperated, and in the case of Zubair, he didn't cooperate. But there's an important point which comes here, which the Supreme Court landmark judgment has said today, that the evidence is in public domain, and therefore perhaps there was no reason to take police remand in his case at all. So yes, on that limited point, I agree. But I would call this Supreme Court judgment a landmark judgment. I would say that this judgment really carries the stamp of Supreme Court authority for a number of things. It has set guidelines to the police and also to the lower judiciary. Look at the kind of remarks it has made and the directions it has given to disband the SIT, which gives a clear direction to the police that don't waste your time in unnecessary cases. It has also said that the person should be released by 6 p.m. That means, you forget about the tortuous process and go through electronic means and release him by 6 p.m. In many cases earlier, they were not being released on the same day. Another important point they have made, which is very, very critical, is that you can't have terms and conditions because he's a journalist and therefore no condition should apply. And the most important, going under Article 32, they have said also bail in future FIR. So I think this is a complete judgment, and yes, it should apply equally to Nupur Sharma. A precedent has been set, and I think this is a fantastic judgment, primarily because D.Y. Chandrachud is known as a protector of fundamental rights.
But Mr. Azad, may I interrupt and ask you for a brief sort of intervention on this? You say that this will send out a massive signal to the police and to the lower judiciary. But the fact of the matter is, whether it is in Jharkhand or in UP or in Rajasthan or in Karnataka, police functions as an extension of the state. Police functions on the basis of political orders. How do you believe and why do you believe that one order by the Supreme Court will change the nature of that behavior?
You see, this fractious debate has been going on for a very, very long time. And I'm sure that the police leaders are now realizing that you just can't get away with arrests of this kind. Some of these arrests are so arbitrary, so unwarranted, and especially after Anesh Kumar guidelines and this landmark judgment by the Supreme Court, I'm sure that some of the leaders at least will stand firm. And I hope even state governments will appreciate that they have to follow some norms and some rules.
Okay, let me ask Swapnil Kothari. A few days ago, we had no less than the Chief Justice of India famously say that in India, the process, unfortunately, has become the punishment. And I can't cite two better examples in recent times, whether it's Nupur Sharma or Mohammad Zubair, where clearly the process had become the punishment. So I want to ask if that has been upheld today by the Supreme Court in the Zubair matter, where it said that seemingly he was being made to run around for the same cause of action. A, should that not apply to Nupur Sharma as well? And B, if there is demonstrable evidence to show that basis some of the comments that a particular bench of the Supreme Court made, she was getting death and rape threats, then doesn't the duty of the court to protect the fundamental rights of every citizen, in this case Article 32 is what she moved, doesn't that take primacy over any state action?
Zaka, to answer question number A, it's very apparent that there is a stark distinction between the two cases, that of Mohammad Zubair and Nupur Sharma. The first is that here you were dealing with the bail application, and there you were dealing with a preemptive arrest, and you were trying to look at clubbing of the FIRs. So, in simpler words, Nupur Sharma had not been arrested. Secondly, although the Supreme Court has won, the judges are different. Every judge has a different perspective on certain aspects, and you have to live with that. It's unfortunate for lawyers. It's unfortunate for citizens. It's unfortunate for a lot of people who litigate before the highest court of the land. And that's the way it is. Some judges are strict. Some judges are different. Some judges have a different perspective on outlook. Some judges are very, very fight shy of Article 32 and giving reliefs under that. Now, the thing is that Justice Chandrachud is known to be a custodian of fundamental rights. He did so very, very unequivocally and very, very vocally, should I say, in Arnab Goswami's case, and came down heavily on the Maharashtra state at that time, saying that weaponization of the criminal justice system is absolutely taboo in a democracy. And especially in a country, a democracy of 125 crores, where state governments, as you said, that sometimes the police authorities act as an extension of the state. So the totalitarian regimes, that is what the Supreme Court is trying to ward off, because those always tiptoe behind a democracy which is so vivacious and so throbbing. And dissent is nothing but an oxygen of the democracy. And to what extent should dissents be made? Whether they qualify as a hate speech or whether they qualify as a justifiable dissent, that is eventually for the courts to decide. But when you and I take a look at it, it is very, very apparent that Nupur Sharma has got the relief. Yes, I agree, a tad bit too late. She should have got it on the 1st of July itself. Scathing comments, maybe they have a reason. I may not agree with the way the scathing comments came, but be that as it may, they have altered that and they have not expunged the remarks, and they've said that till August 10th, you can go ahead and exercise an alternative remedy and go before the Delhi High Court. Possibly that is what she will do, and she should do, rather than wait for August 10th.
No, but
so
Swapnil,
to look at your principle.
The principle, that's what I'm saying. I agree. No two human beings are the same. No two judges are the same. Maybe interpretation of the law is different. That's fine. That's acceptable. But the principle has to be the same.
I completely agree with you, Zaka, that the principle has to be same, and that is the reason why I just told you that that judgment should have come on the 1st of July itself, of clubbing the FIRs or saying that please go to an alternative court where you have an alternative remedy, because we are a little sherry of invoking Article 32 or exercising a jurisdiction which we already have on the basis of several principles and principles of fairness, equity and everything. But that's another perspective of it. That's the way some judges look at it. But I completely agree with you that with this judgment, it is an absolutely landmark judgment, and it will give a tremendous amount of fillip to the fundamental rights, to Article 32, to Part 3 of the Constitution, which is the life breath of our democracy, and several states which have an open mind, which will look at it very seriously and possibly even go to the extent of informing the police officers that, look, you have the power of arrest and your criminal law will always be subjugated and will be obsequious to the constitutional law. And if you do not do so, then the Supreme Court will step in as the sentinel qui-vive, that is the custodian of the Constitution, and throw its weight around and put a final stamp of authority in saying that we are the final arbiters and we will decide and dictate and govern the country as per the rule of law and not as per the whims and caprices of any state government or any of the bandicoots that rule it.
The people who face this, the arbitrariness of having multiple FIRs for the same offense, the most happen to be journalists. Today, any of you can say something incendiary on this show, and not only will you be charged, I will also be charged as the editor of the show and the editor of this channel, and I could have multiple FIRs in different states and perhaps even multiple FIRs in the same state, as has happened to one of my colleagues in our Hindi network. So, Smita, will today's judgment set a benchmark, if you will, in this day and age of social media and electronic media, where, you know, for one comment made in one television show, you have multiple FIRs either in the same state or multiple FIRs in different states? Will journalists be protected by the power of today's judgment?
Well, Zaka, this being hailed as a landmark judgment and the eminent judge being called the upholder of democracy, I will stay clear of these hyperbolic statements. I'm no legal, so I'm just a journalist like you, so I'm not going to talk about it. But yes, I do say that bail should be the rule and jail an exception. And for long, that has not been the case. And while many would like to believe that it's only since 2014 that that's not the case, the truth is for decades it's been that. In my limited knowledge, that is what I have seen happening in the courts. As far as you're talking about the FIRs and the clubbing and all, I mean, I'm sure legal eagles will now bring up the Arnab Goswami case, the Rajiv Ranjan, Amish Degan, as you pointed out. All these cases will come about and they're saying that club all of them together, and that should happen. The courts have to be impartial and not be influenced, to say that bandicoots ruling the country and all that. I hope to God that judges aren't watching this show and are not influenced by this kind of talk, because I would hate to think that they are influenced by a political party or by another political party, and they should ensure that citizens don't feel that, that the judges, as Ratan Sharda said, that it's not enough to just for the judiciary to be acting, it should be seen to be acting impartially. So I think observations that the judges make, those are also important. So far we've seen and we've been told that it's the written judgment that should be seen and not just the observations. But I'm afraid that now, provocative and statements made in the court, they probably are made to shock and awe and to provoke the lawyers. But I'm sure, like me, millions were really shocked to hear words like loose-tongued and things like that used, arrogant, against Nupur. It can be said in WhatsApp groups or in living rooms, but when it is said in the apex court, it really makes one wonder whether it is whether the judiciary is being swayed or not by what it is seeing around, whether in the media or whether by political mechanisms which are in place these days.
No, and more importantly, the impact that those words could potentially have on lower court judges who ultimately will decide on these cases. I mean, no one wants to be seen as rubbing a Supreme Court judge, even if it's oral observations, the wrong way. But I want to come back to Ratan Sharda and please respond to the points made by both Adil as well as Yashwardhan Azad. They feel that the Nupur case and the Zubair case are apples and oranges because in one case, arrest has happened, he's being taken to multiple locations, multiple FIRs in multiple states, and as one of the judges said, the process is the punishment is applicable to him. In the other case, arrest has not happened, even though explicit directions of no coercive action only came yesterday, over a month after she made those objectionable comments.
Saka, everybody has rightly pointed out that the comparison between two is apple and orange, but who is apple, who is orange, I would not get into the debate. Yesterday I debated the same point. I don't want to go back to that debate because clearly the case of Nupur Sharma was a heated debate. Case of this Zubair was deliberately created, cold-bloodedly with a select clip and then displayed, broadcast all over different language networks to instigate the people. So this is the basic difference. As far as Nupur's arrest is concerned, everybody knows she was threatened with beheading right from day one. So should be counted. People who were arrested also got killed. So should that not be accounted for? Coming to other point, Gopal had talked about Ratan Lal many times, my namesake. But remember, Ratan Lal was released the very next day. Ketaki Chitale, as junior, no politician at all, was in jail for 40 days. And when you say judges should avoid, that people should be following the law and all this big hyperbole like Sunita said, Smita said, landmark judgment and all that. That is also true of judges. Should judges be using such language which can be then expunged and said, okay, this was not part of the judgment? Because those words were used repeatedly on all the TV channels, continuously by all the people. So this was a huge, I would say, kind of language should be avoided. And if they say clubbing together is a norm, then why her case was not a club? So when you ask others to follow those landmark judgments at all, should judges not follow their own landmark judgments? We talk of Arnab Goswami, where his case was clubbed, but despite court's strictures, right from High Court to Supreme Court, many of his employees are arrested. Hundreds of cases were put up. They were not afraid of the court. So I think this respect for the court comes from the politicians, those police people who follow the politicians. It will happen only when politicians decide that enough is enough. We should not be using law for ulterior motives. And also with due respect to courts, they should also be following standards they themselves set.
No, this is what the Supreme Court said in the 2020 case of Arnab Goswami versus the state of Maharashtra, that subjecting an individual to numerous proceedings arising in different jurisdictions on the basis of the same cause of action is a violation of fundamental rights, Adil Boparai. So if it applies to Arnab Goswami, it should apply to Ketki Chitale, and it should apply to Nupur Sharma just as much as it applies to Mohammed Zubair.
Zara, 10 seconds. I also pointed out that there were other employees harassed despite the strictures.
Okay. All right. Yes, Adil.
Absolutely, Zaka, you are spot on, and therefore a brave and a courageous journalist like yourself should put this question to the Home Minister of this country, that why are you allowing multiple FIRs to be registered? After all, it is the Ministry of Home Affairs which is the cadre controlling authority for the Indian Police Service. And under Section 36 of the CRPC, it is the senior officers, the IPS officers who are superintendents over investigation.
No, but so Adil, you know as well as I do. No, one small correction, one factual correction. You know as well as I do that police reports to the state governments. Police is under the state government, the Home Department of various state governments, and it's on the instructions of state governments or influence of state governments that these FIRs are filed.
And anyway, then put this question to the UP Chief Minister. Will you put this question to the UP Chief Minister?
As much as we would, we would put this. We would put this to the Rajasthan Chief Minister, to the Chhattisgarh Chief Minister, as much as we would put this to the UP Chief Minister. Fair enough. Fair enough. Yeah. Okay. Go ahead. Yeah.
But something which is so fundamental, perhaps not being understood by some of your panelists, which is that there is a fundamental distinction between making a hate speech and reporting a hate speech. So if tomorrow Zaka Jacob reports a hate speech, he cannot be booked for that, as opposed to somebody who makes a hate speech.
Okay.
Having said this, I think the bigger issue here is executive high-handedness. It is not that there have not been judgments in the past. Mr. Azad referred to the Arnesh Kumar judgment. Arnesh Kumar judgment of the Supreme Court says that you should not make an arrest if the sentence is less than 7 years. Now, in the case of Zubair, the sentence is less than 7 years. So the problem is not that there is a vacuum on the legal canvas. The problem is police high-handedness. Now, let me finally say something, and this I'm saying as a citizen of this country, cutting across political lines. It is time that you hold the senior police officers accountable. Whenever there is an arbitrary arrest, whenever the Arnesh Kumar judgment is brazenly violated, it is time that the courts hold the police officers accountable. Because as long as you don't do that, there will be you will continue to have high-handed and arbitrary arrests.
No, but so again, even if the police are pulled up, even if the police are pulled up, you know as well as I do that police most times in high-profile cases such as this act on the instructions, explicit or otherwise, from political authority. No, anyway, let me. I want to ask the question that you raised, and I think it's a fair point. Swapnil Kothari, to respond to what Adil said, that there is a difference between making a hate speech and reporting a hate speech. Swapnil.
Yes, there is definite distinction between that because as a reporter, as a journalist, you are entitled to report that this is what the gentleman said and this is what the hate speech was. And so obviously you will not be booked for that. You've just done a mere reportage. You are
but Zubair says that he's not a journalist.
Right.
Zubair says he's not a journalist.
Defense. Well, let the trial begin. Let the court come to a conclusion because that is his defense. Now, to come to the point that whether the courts are influenced today by the bandicoots who rule the state government, it is absurd for anyone to suggest that there are in fact bandicoots who rule some governments and the courts are very little influenced. That's the reason why the Chief Justice over the weekend stated that we are not at the behest of the court. Any state government should not expect us to do or take us for granted for anything. We will simply abide by the Constitution. Okay. And as far as using hyperbolic statements are concerned, to say that this is a landmark judgment, this is a pure legalese, and the courts need to be praised because it is simply the judiciary which is running the country. Let me be very honest about that. Cutting across political lines, it is absolutely the judiciary which is preventing or in fact supporting and protecting and being the champion of the free speech.
I'll get Smita to respond to that. That will be a nice closing note. But Yasho Azad also wanted to make a point about what Adil said. Go ahead. Can you, Yasho Azad, without police being taken out of political interference, ever expect that lower judiciary or police are not going to listen to diktats of the state or diktats of political authority to file these FIRs solely for the purpose of harassment?
Well, these are what you call the state-sponsored FIRs. There are some policemen who will stand by their own conscience and they will not do it and they'll be kicked out. But let me say one thing, even at the cost of being said that they are hyperbolic statements, and whether the judiciary watches the TV debates or not, I still maintain it's a landmark judgment and it should be applied both to Nupur Sharma and also in this case.
Okay, I'll give the final word to Smita. Smita, to respond to what Swapnil said, that he believes that the Supreme Court is the only institution that is upholding freedom of speech in this country.
Completely, absolutely disagree with that statement. Firstly, I think it is doing disservice to our legislature, our executive, and our media also by terming everybody other than the judiciary as bandicoots. I think they are pillars of democracy. We have our fault lines. There are fissures in our country. We are not the perfect democracy. We have a lot to learn and a lot to remedy our institutions. But to say that judiciary is the only untarnished, spotless, pure as driven snow pillar of our democracy, I think is simplifying the argument completely.
Okay, I'll leave it at that. Thank you very much. I'm completely out of time. Smita Prakash, Swapnil Kothari, Yashwardhan Azad, Adil Boparai, and of course Mr. Ratan Sharda for joining us. It is a fascinating debate and I don't think the final word on this has been said yet. But having said that, today's judgment will go a significant way in protecting civil liberties, in protecting that not just journalists but every citizen of this country has the right to free speech, and that the power of arrest cannot be used as an instrument to intimidate by the state, whether it is in the case of Zubair or whether it is in the case of Nupur Sharma. Meanwhile, let's shift focus to the other big story. Many are calling him India ka damad. Rishi Sunak is now one step closer to becoming the next Prime Minister of the UK. Today, in the fifth and final round of voting amongst the Tory MPs, Sunak and Liz Truss are the final two candidates who will be in the race to replace Boris Johnson. So let's take a look at how the numbers stack up for both Rishi Sunak as well as Liz Truss. This was the fifth and final vote. In fact, Rishi Sunak getting a substantial number of votes, 137. 120 is that critical factor. He's gone past that, and substantially so. 137 votes is what he ended up with. Liz Truss, who was number 3 up until last night when the fourth round happened, she has now skyrocketed to 113. Penny Mordaunt, who was number 2 at the end of last night's voting, has now dropped out of the contest with just 105 votes. So the final two will be Rishi Sunak and Liz Truss, and they will go up against each other in the battle to be the leader of the Conservative Party and, of course, the Prime Minister of Britain. All right, let me first go across to Sanjay Suri, my colleague who's joining us live from London. Professor Scott Lucas is also joining us, an international affairs expert. And Professor David Dunn is from the Department of Political Science at the University of Birmingham. Sanjay, first things first. So it's come down to Rishi Sunak versus Liz Truss. It is a minority Asian candidate, Indian heritage on the one side, former Chancellor of the Exchequer. On the other, it's a woman candidate. And if Liz Truss wins, she will be only the third woman Prime Minister of Britain. So will it be the third woman Prime Minister, or will it be the first non-white Prime Minister of Britain?
Well, it's a little difficult to try and quantify relative levels of prejudice and to try and balance the level of prejudice over racial issues with that on gender issues. I think that is an unquantifiable factor, which is not to say it's not existent. It certainly is going to play a role, and that's what we're going to see in the next few weeks. This is going to be a debate at two levels. At the visible, audible level, this is going to be about the economy, and Sunak and Truss have clashed before, and Truss really will be in a spot to try and seek to defend her arguments over tax cuts, which Sunak has challenged. Clearly, there will be a debate at that level. But then again, as you point out, India's boast can be Rishi Sunak's embarrassment here. Bharat ka damad will be seen by many people as an outsider, not in so many words. Nobody says these things. But given the profile of Tory membership, it's also very difficult to say that this will not be a factor.
Professor Scott Lucas, I think it's very, very important to underline it's not Britain that's voting for its next Prime Minister. It is the Conservative Party that is voting for its next Prime Minister. In a party where 97% of its members, close to 200,000 of them, are white, are they ready for a non-white leader of that party and, of course, eventually the Prime Minister of Britain?
Well, I think Rishi Sunak has an uphill task, at least where we stand today. The two, I think, polls to watch. One is from YouGov. He trails Truss by 54 to 35. There's a Conservative Home poll where he trails 49 to 42. I do think ethnicity plays a part here. I do think gender may play a part, but not really that much. And it's quite notable that Liz Truss is trying to model herself, even dressing like Margaret Thatcher to try to bring back the Iron Lady. I think there are other issues that are here. I think there's a question as to whether Rishi Sunak, who is seen here as being very well off, and he is, but who also was embroiled in problems over his finances a few months ago, whether he can overcome that. I think there are issues in terms of which of the two is seen as being competent. Rishi Sunak has been Chancellor of the Exchequer, but had a pretty rough few months at the start of the year. Liz Truss has been Foreign Secretary, but has been a bit lightweight. And then finally, I think there is going to be a question here, and I'm not sure if Conservative Party members will pick up on it, but Liz Truss is a political chameleon. She was a Remainer. She did not support Brexit. She was once a Liberal Democrat. She has now tried to rebrand herself as a very right-wing conservative. Will the Conservative members buy it? And final one wild card, just to put in this, it'll be the Boris Johnson camp. There are still a few people around him, and they are going to go all out for Truss. They despise Sunak, and they will try to use any means to keep him out of number 10.
I want to ask exactly that to Professor David Dunn, because I think the elephant in the room, if I can use that phrase, is the Boris Johnson factor. I think Boris Johnson, in the media reported this as well, apparently told some of his aides, anyone but Sunak. He feels that Sunak was the one who, stabbed him from the back and turned the knife in, and that's what brought about the downfall of his government. Now, that's debatable, but be that as it may, if the Boris Johnson folks in the Conservative Party are going to go lock, stock and barrel with Liz Truss, then does Sunak stand a chance?
I think it's a very good question. I think it's very clear that actually among that tiny electorate, we're talking about 170,000 people, at roughly 0.3% of the wider electorate. Of those people, there's a lot of loyalty to Boris Johnson. They were the person who put him there by a much bigger majority last time there was a contest for the Conservative Party. And they are older, whiter, more male, more southern, actually much more conservative. And that's partly why Liz Truss is playing to the right to come across as this much more right-wing character than she has been previously, to try and corner that market. But I think actually what may determine this is the nature of the next 5 weeks, because we saw with the race that Theresa May was against, her candidate self-destructed. And there's an entire possibility that Liz Truss in particular could self-destruct by some gaffe or other in the next 5 weeks. She is not the brightest knife in the block, and she is someone who is very good at well-rehearsed speeches and set lines. But in open debate and in open questioning, she's also capable of putting her foot right in it. And that may ultimately play to Sunak's advantage, who is the much brighter and much more seasoned and experienced politician of the two.
Okay, give me a moment. I request all three of you to stand by for a minute. We also have CNN's Bianca Nobilo joining us live from London. Thanks very much, Bianca, for speaking with us. First things first, Sunak has also had his fair share of controversies, most notably with his wife's tax status, her domicile status. Will he be able to overcome this and win the Conservative Party leadership fight?
Well, one of the biggest issues that's looming over this leadership contest is the issues that the party is having with its brand. And that's happened because of the legacy of the Boris Johnson years, and particularly the last year, which was embroiled in so many scandals, that public trust has been eroded to such an extent that one of the chief objectives of this next person will be to try and restore that, to let the electorate have faith in them, to build that trust back, and to be somebody who is, I suppose, cleaner and less scandalous than before. You know, that's very important, and that's why they're setting out their stalls in the way that they have. Whether or not Rishi Sunak can recover, as your previous guest mentioned, I think it depends what happens in the campaign, whether or not Liz Truss is subject to these gaffes that she's famous for. I'm thinking particularly of the speech she gave to party conference in 2014 when she opined about British agriculture and cheese. It will really depend on how these candidates play off against each other and those unpredictable issues which arise in campaigns, which no one can ever predict. For example, the leadership contest between Theresa May and Andrea Leadsom at the end there, where Andrea Leadsom made some comments about having a greater stake in the future of the country because she had children, whereas Theresa May didn't. And this became a real hot button issue and backfired terribly, and no one could have predicted that at the beginning. So we don't know at this stage what it's going to be that will define this contest going forward. But I think Rishi Sunak and Liz Truss, as they pull neck and neck with membership, have equally good chances as things stand right now of winning that spot.
And Bianca, very quickly, just in terms of, and I'd like to see this vote as it's a simplistic way of looking at it, but it's clearly a Bojo vote and an anti-Bojo vote. Clearly, Sunak is the anti-Bojo candidate and Liz Truss is the Boris Johnson candidate. Will the Conservative Party, the 180,000 of them, decide this race on that basis? I've got the candidate that I don't like Boris Johnson, I don't like what he did, therefore I'm voting for Sunak, or I'm still with Boris Johnson, I don't like what happened to him, and therefore I'm voting for Liz Truss.
Well, the membership that I've been speaking to recently reflects the pragmatism that the Conservative Party can sometimes display. They are keen to move on from the fatigue of the scandals and the issues that we've seen in the Johnson years. Many of them still remain loyal. We've had in recent days a push from a small fraction of the membership to have Boris Johnson be an option in this leadership contest, which has obviously failed and won't be happening. So I think the candidates will be keen not to completely discount the achievements and the legacy of Boris Johnson, because they know that he did inspire loyalty for a long time in the party. So I'm not sure it will be quite as simple as that. I think the party's main concern will be the electability of the candidate. And now Boris Johnson, for all of his faults, whether people love him or hate him, dominated the political scene. He was hugely electable back in the day and managed to deliver these historic election victories for Britain and win over voters in traditionally Labour urban areas, as well as maybe more liberal-leaning areas in the south. They'll want to see an example that this candidate who could become Prime Minister will be able to secure the Conservatives' electoral future, which right now is looking bleak.
All right, Bianca Nobilo, thanks very much for joining us live from London for us tonight. Let me go back to Sanjay. I want to look a little further ahead, not just on this prime ministerial battle. Before I go to Sanjay, I've got the latest bite from Rishi Sunak. In fact, he's spoken right after winning this fifth and final round, where he has come as number one and Liz Truss is number two. So it's going to be a runoff between the two of them. This is what he had to say.
Well, we've just got the results, and wow, thank you so much to everyone for your support. I'm so humbled by it, and I'm delighted that we got to this stage in the contest. I won't let you down. I'll work as hard as I can to get our message out to the country. We need to restore trust, rebuild the economy and reunite our country. I'm confident that we can do that, and we've got a really positive message to take out to all our members now. Crucially, who is the best person to beat Keir Starmer and the Labour Party at the next election? I believe I'm the only candidate who can do that, and that's what we're going to talk to all our members about now. But thanks for all your support so far. Please come and join the team. Sign up at readyforrishi.com, and I hopefully see you on the road soon. Well,
you know, I want to take off from where he finished, Sanjay, where he basically said the number one priority would be beating Labour 2 years from now. Do you believe Sunak would be the best person to beat Labour 2 years from now, or Truss?
Well, that might be a little difficult to guess into at the moment. Clearly, the focus now is on beating Truss. And if it comes to beating Truss, certainly if that were to be decided by debate and argument, he will. There's no question. He is very much the better qualified person. He has the mind, he has the experience. Liz Truss stands no chance against him. The fear is that this will not be decided by debate and by argument, but by prejudice, by subterranean factors that are difficult to quantify, that are usually never expressed, but are of course not for that reason any less real. And of course we will see that through these hustings and these next few weeks, who comes across as more convincing, and the more convincing they appear, the better chance the party members will see in that they will be the one to beat Labour.
Okay, we'll leave it at that. I want to thank all our guests, Sanjay, Professor Lucas and Professor Dunn. If this contest were to happen not in the Conservative Party in Britain, but on Indian Twitter and Indian YouTube, I tell you what, Rishi Sunak will win with a landslide majority. You should go to youtube.com/CNN News 18, look at some of our videos and live streams on Rishi Sunak. It's gone through the roof. Like I said at the top of the show, many in India here feel he is Bharat ka damad. All right, I'm going to take a quick break. When we come back on the other side, there's been a 5-hour encounter in Punjab, very close to the Atari border. 2 of Sidhu Moosewala's killers have been eliminated in that encounter. Details right on the other side.